that still don't know me in the profession. My name is Casey Makubele. I am the CEO of the South African Dental Association. We are very excited today to welcome you to this first night of our taste of what would have been if COVID did not happen in terms of our Congress. And the Congress would have been called Stronger Together. So here we are. We're giving you that taste of what would have happened in those meetings. Please refrain from using the raised hand, but type your comments or questions on the Q&A tab. Also, please note that the CPD certificates will be loaded to the SADA platform, and you will be able to access all your certificates under your membership profile. Even if you're not a member of SADA, to get into this meeting, you would have had to register. And if not, you will be required to register and you'll be able to get your certificate. But if should you struggle, please call the office and we'll email the certificate to you. The event for tonight qualifies you for 1 ethical CEU points. And it's one of those extra points that we are allowing members to have. We are streaming live on YouTube, just in case you have difficulty to access the Zoom platform, or should you wish your family to join because maybe you want them to be dentists as well. After the countdown has started, well, after we've started everything, we're going to allow the speakers to take their time and speak. So please remember, as well as remember, to complete the evaluation after the webinar. And just by way of informing you what is to come after tonight, we have other great, exciting webinars. But just for tonight, there will be a lucky draw. The Stroman Group product voucher worth 5,000 and Ivodent Sunstart Oral Care Hamper. Make sure that you are here until we announce or we start the process of the winner. The winner will only be announced tomorrow. So please ensure that you stay on and then come in tomorrow to see who is the winner. We've got 3 more meetings around this banner of Stronger Together. 1 December, Dr. Martin Wenendeya, Bring the Team Together, will be speaking to us on the 1st of December. On that day, there will be another lucky draw of 2 Dentsply Serona gift packs worth 5,000 each and a J&J Listerine hamper. Again, make sure you are there. 2nd December, Dr. Dale Miles, Conbeam, More Than 50 Shades of Grace. This is sponsored by SI Vision. There will also be a lucky draw by Henry Schein Dental Warehouse voucher worth 2,000 and J&J Listerine hamper. On the 3rd of December, which is our last day, Dr. Ricardo Martini, How to Create a New Vision for Your Dental Practice. Lucky draw, Ultradent Bleaching hamper worth 14,600 and Millwright gift packs multiplied by 2. By the way, this is what we have, but we may get even more stuff. So be ready for even sport hampers and sport winning stuff. So we're very excited. I will do this at a later stage in terms of the choosing of the winner. In terms of our panelists, guys, we have, of course, staff members that are assisting here, but we have the speakers, Alasdair McKelvie. I don't need to say much about him. You would have seen all the information about him. And we've got Dr. Yash Naido, and they will be speaking today. Dr. McKelvie will go first, and then Dr. Naido will go second. We will then have a question and discussion time where the panelists will be giving you information. So thank you very much for all of you that are here. If you are having trouble or anyone is having trouble, please, you can get hold of our Norman Kiwane or Tsepo. I would suggest you use Tsepo more today, 061-463-5791, 061-463-5791, so that we can assist you or Tsepo can assist you. Thank you very much. I think without going into the Alasdair's profile, I would just like to go to Dr. Yash Naido's profile slightly. He's a case manager, MPS, South Africa. He's a former healthcare and dispute resolution attorney at 2 South African so-called Big 5 firms. It's actually called Big 5 firms, law firms. His legal Experience include assisting private and public healthcare institutions in defending medical malpractice claim, assisting healthcare practitioners and institutions with proceedings before their regulators such as HPCSA, SAPC, or HSC, HPCSA, advising clients in respect of South African healthcare regulation, and assisting foreign qualified medical practitioners in obtaining registration with the HPCSA. Prior to starting his legal career, Dr. Naido qualified and practiced as a dentist. While practicing dentistry full-time in the public sector, he obtained his LLB from the University of South Africa, cum laude. He joined MPS in August 2020. So we're looking forward to an exciting evening. Ladies and gentlemen, for the next 4 evenings, including today, really I would like to suggest that you ensure that you join us, you do not miss anything. Without further ado, I would like to hand over to Dr. Alasdair McKelvie. Alasdair, welcome.
Thank you, Casey, and thank you for that introduction. Good evening, everybody. Welcome to SADA Education Week 2020. Normally, Casey does not let me lead off the SADA Congress, and he usually lets me speak first thing on a Sunday morning when everybody's still in their beds or they've probably gone home. So it's an absolute privilege to be kicking off your week. So I'm just going to go through this process, Casey, of sharing the screen and making sure that everybody's seeing the right thing. So if you can confirm that you can see my slide.
We can see the slide.
Thank you, Casey. So yeah, this is a new one for dental protection. We're going to be talking about dental legal myths, and we're going to bust some myths tonight. The reason why I've chosen to do some myth busting is because across all of our events this year, we've had lots of feedback from our members in South Africa and asking us questions around some law and ethics issues in dentistry, and where there may be one or two or even three interpretations, one of which is a myth. So that's what we're going to talk about tonight. And for anybody who doesn't know me, I work for Dental Protection, and we are the leading provider of comprehensive professional indemnity and expert advice to dentists and healthcare professionals around the world. We've got over 68,000 members the last time I counted. We're a member-owned mutual organisation, and it's a bit like a sports club. So all of our members pay a subscription, and in return we provide advice, support, representation, defence, and we pay compensation on your behalf when things go wrong. So let's get straight into the action. So the first myth you can see on your screen should be the one about the patient signed a consent form, so I can't be sued if they suffer a complication, which was listed. So this is the myth around, if I get the patient to sign the consent form, then no matter what goes wrong, it's their fault. So this is a particularly good myth to bust. And for years, there's been demand from Dental Protection to develop consent forms for our members to use. Feedback from every webinar or online event we do includes this request for a consent form. And we've always said no, because there's a danger that by creating the form and the box for a signature, we change unintentionally the dynamics of the consent process from an informed conversation into an uninformed read. So in claims for damages based on the negligent failure to warn a patient of material risks or complications in dental treatment, the courts in South Africa will employ a patient-based approach. And the reason for this is that a patient's right to self-determination includes the right to decide whether they want to have that treatment or decline it. And in consenting to treatment, the patient accepts responsibility for the unintended harm that can sometimes happen. However, to do this, the patient must have knowledge and must appreciate the extent of risk or harm they are accepting. The knowledge comes from a discussion and not a consent form. Instead of a discussion, so the discussion without a consent form is acceptable from a legal perspective. Proving the discussion took place in the absence of a record or consent form comes down to whose evidence a court prefers and the reliability of each witness. A signed consent form may indeed be evidence of a discussion, but it's not specific to each individual patient's treatment. From a documentation perspective, the discussion and a short, concise note in the records of what was discussed and agreed is arguably more effective than a generic consent form. So the second point I want to make tonight around consent is that a signed consent form does not exclude a negligent action. So in agreeing to proceed with the treatment, a patient does so on the basis that the dentist will provide a reasonable standard of care at all times. If the investigation, planning, discussions, and execution of that treatment was undertaken in a negligent fashion, then the consent form, even if it is signed by the patient, will not protect the dentist from a complaint or claim. And the third topic I want to briefly mention at this point is the disclaimer. And during the pandemic, and particularly returning to work, some of you will ask your patients to sign a disclaimer to protect you from an allegation or claim that a patient caught COVID during a visit to your practice. So I know a lot of you were asking patients to sign this disclaimer, and at first look, it's probably not a bad thing to consider. We see disclaimers everywhere, and the reality is that a disclaimer is not watertight for the following reasons in dentistry. So the first thing we need to understand is that a patient cannot consent to negligence and is likely to be told that the disclaimer is not enforceable in the event that your infection control protocols and use of PPE, for example, fell below the reasonable standard of care expected of you. You also cannot contract out of your common law duty of care, as the duty of care is absolute. Now, what this means is that your duty of care remains despite the disclaimer. And the final point I think I want to make is that requiring a patient to sign a disclaimer precluding them from suing for damages would probably constitute unprofessional or unethical conduct in most jurisdictions, as the disclaimer seeks to place your interests, the interests of the clinician, above those of the patient. And the disclaimer would undermine those ethical principles of non-maleficence and beneficence. So given the power imbalance in the relationship, it also might be regarded as an abuse of the clinician's position. So that's why we think that disclaimers are not going to be particularly effective. So let's move on to myth number 2. When a patient doesn't show for an appointment, I'm entitled to charge that patient a fee equivalent to the treatment fees I would have collected had the patient turned up. So this is about missed appointments. And missed appointments, patients who turn up, create a significant problem for colleagues everywhere in the world. Wasted appointments are frustrating for us. Non-attendance by patients is clearly a drain on practitioner resources for several reasons. The first reason is economic. So the cost of each missed appointment will vary according to individual practice overhead costs. And the second is manpower. If a patient doesn't turn up for the treatment, the surgery is empty and someone else is deprived the opportunity to see the dentist or their staff. So non-attendance means underutilization of equipment and manpower. So let's look at the legal and ethical constraints around charging for no-shows. So the legal basis for this comes, funnily enough, from the Consumer Protection Act at Section 17, which permits a service provider, which is a dentist, to charge a reasonable fee for the missed appointment. Now, a no-show charge is considered reasonable if the following 4 conditions are met. So the first one is that the patient just doesn't turn up, no notice is given for the missed appointment, or the patient has given notice, but it is less than 2 hours notice and less than 24 hours notice for a specialist. So the patient must give you 2 hours notice for an appointment at a general dental practice and 24 hours notice for an appointment with a specialist. The second condition is that you have made reasonable attempts to establish why the appointment was missed. So there is an obligation on you phoning up the patient after they've not turned up to find out the reason. The third condition is that you can demonstrate that the patient was aware there was a practice policy for no-show charging. So what you have to do is you have to make sure that you have a policy that is seen by all of your patients. It is a written policy, and it just needs to be a short notice, a shortly worded notice on your practice notice board, or something that you've got in your website, or something, a form that you can give them along with their appointment card. And the fourth condition is that you can supply evidence that you could not reschedule another patient into the appointment space. And I find this actually quite unreasonable on the basis that most of the time you only find out the patient is not coming when they don't show and you're halfway through the appointment time. So the HPCSA published ethical guidance in 2018 in an e-bulletin supporting the position provided by the Consumer Protection Act. There is, however, an ethical rule that prevents you from charging a patient for services not personally rendered. So this rule would prevent you submitting a claim to the patient's medical aid for the services that would have been rendered had the patient attended for the appointment. So you can't do that. But we have some tips here for avoiding problems when you charge patients for no-shows. Number one tip is make sure you have a written policy that explains how you will manage no-shows. Number two tip is before you render a no-show charge, find out the reason for the patient not attending, because emergencies or car issues can happen when they're least expected. And you need to give your staff discretion to decide when to apply a charge or not. If it's the first time somebody's not turned up and it's one of your patients who's a great advocate for the practice, then you might want to say, on this occasion, we'll not charge you a missed appointment fee, but we will next time. The other thing that is recommended, as a tip that's recommended, is send patients a reminder for any treatment sessions over 30 minutes, maybe the day before. The problem with this approach is that patients get accustomed to receiving a reminder and are not as diligent when writing their appointments in their diaries. And then when they don't show because someone forgot to remind them, it becomes a problem. So sending reminders is no more than a professional courtesy, and it's not a binding agreement just in case they think it is. So a very common myth: a fractured endodontic file is a recognized complication. It's not my fault, and the patient must pay for the removal of the file. Well, yep, a file fracture is a recognized complication of an endodontic treatment, but if it's the first time the patient knows it's a risk when it's happened, you may well have a problem. And there are a number of areas of risk that increase the chances of file fracture that we probably need to discuss at this point. So the first thing I think we need to do is we need to carry out an assessment of the tooth before treatment begins. And to do that, you need a good periapical radiograph of the tooth so you can identify any increased risk of file damage due to sclerosis or root canal anatomy. If you see something in the X-ray that will increase the risk of a file fracture, then that needs to be discussed with your patient. Second thing I need you to do, for the consent process to be valid, the patient must understand that there is a risk of file fracture, what that risk will mean for them from a procedural and cost perspective if it happens, and anything that you can do to reduce that risk. So the evidence will show that the risk of file fracture in many cases will be lower in the hands of an endodontist or a colleague with a particular interest in endodontics. That's just stats. I know that there are very many competent GDPs who carry out endo without file fracture, but the evidence will show the contrary. So the majority of routine endo should be within the competency of most GDPs, but if the tooth inherently gives rise to an increased risk of file fracture, then you may need to discuss the option of referral. Endodontists are not just there for the treatment of failed endo and file recovery. They have this expertise to undertake more complex procedures from the outset. So don't forget to think about referring your patient if you feel anxious about a challenge and the potential for file fracture. The other thing we need to remember is that a poor or substandard access cavity increases the risk of file fracture. So you've got to make sure you get your access cavity right. And it's also important to remember that all files and rotary equipment are used following the correct protocols for the sequence and handling of the instruments. So in summary then, advising the patient that file fracture is a recognised risk when the file breaks is just too late. So there's no point you saying, well, it's a recognised risk, because the patient will say, well, if it's a recognised risk, how did I not know about it? You also need to assess if there's an increased risk of file fracture caused by the anatomy of the tooth, and discuss referral if it is an option. And then when you use the files, please make sure that you use them in a way that they're designed to be used. If you get all these points aligned correctly, then when the file breaks, it was expected, the patient knows it's not your fault, and they know they're going to have to pay for some additional treatment to have the file recovered from the root. So let's move on to myth number 4. And here it is. I've been asked to disclose treatment records by the medical aid so they can undertake a claim to record check. They say that their member has given consent, so it's okay to provide them with this information. Well, do medical aids have a right of access to the treatment records of your patients? Well, this issue has been conflated by the HPCSA in May 2019, where they suggested that the medical scheme has an entitlement to access any treatment record held by a healthcare provider without the permission or without the consent of the member of the medical aid. And they were quoting regulations from the Medical Schemes Act, which applies only to those providers who are contracted with the medical scheme. The provisions of this Act are subordinate also to any other legislation, which means that superior legislation takes precedence. And the defining precedent law in South Africa is the National Health Act. So the key issue here is that patient confidentiality trumps the Medical Schemes Act. The National Health Act identifies only 3 situations where patient records can be disclosed by a dentist. The first situation is where the patient has consented to the disclosure. The second, where the disclosure is ordered by a court. Or the third one, where the disclosure is required in situations where non-disclosure could cause a serious risk to public health. So if we take all this into account, the disclosure of patient records to a medical scheme should not be completed without permission of the patient. So what you need to do when you get asked to supply medical records is you must write to your patient, explain what's been asked for, and ask them to confirm their decision in writing either way. Either yes, you can disclose my records, or no, you won't, and keep that letter. Patients do actually sign an agreement when they contract with a medical scheme, but it's a one-off situation. It happens right at the beginning. And we all know from our discussions that consent is not a one-off event. And even if the scheme references that consent may have been superseded by a whole load of health interventions and problems that the patient no longer wants disclosed to their medical scheme. So the myth is, if you're asked, do not disclose without patient permission. That's the safe way to proceed. So myth number 5, you can sue a patient who reports you to the HPCSA where no disciplinary action or a sanction is taken by the HPCSA against you. Now, I guess that everybody was hoping that this myth is not a myth, and that you actually can sue every patient who reports you to the HPCSA. Well, a complaint to the HPCSA when it happens is probably one of the most worrying events in a professional career. And when it happens, there can be a mix of emotions from fear to anger. And it's not unusual for many of our colleagues out there to consider a legal challenge for damages where the complaint appears frivolous or untrue and contains distressing and defamatory allegations. We get asked all the time, what is the potential for me going after the patient? And human nature is that we want to fight back and retaliate. So the perpetrator suffers a similar pain and loss that you have, particularly where no findings are made against you by the HPCSA, so you can exact retribution through the civil courts. So the South African Constitution gives individuals, these are your patients, the right to have any dispute that can be resolved by the law, heard and decided by the courts or another independent or impartial tribunal or forum, like, for example, the HPCSA. And to threaten a patient with a possible loss when they genuinely held concerns about their care would undermine their regulatory function and process and would act as a disincentive were it permitted. It would also not fulfill the public interest if patients were prevented or persuaded from raising genuine concerns about their dentists. So communications between patients and the HPCSA are privileged because patients are entitled to complain, and the HPCSA has a reciprocal interest in receiving such information. The only circumstances where you can sue a patient arise where you can prove their actions were malicious. And there are 4 threads to a successful prosecution for malicious behaviour. First of all, the patient needs to have been the one who made the complaint. And secondly, that the patient did so without reasonable and probable cause. The third thing you've got to prove is that the patient acted with malice. And the fourth thing, the HPCSA found no merit in the complaint and no grounds for sanction. So proving malicious intent is incredibly difficult, and litigating a patient for malicious defamation is likely to generate the public interest. Opinion can be divided. Are patients in general going to react well when they hear in a newspaper that a dentist is suing a patient? You can hear them saying, look, the patient dared to criticise their dentist to warn other patients, and now he's threatening them with a civil writ. And the dentist must prove that the patient intentionally made the complaint knowing it was untrue. That's really difficult. It's also really difficult to provide evidence of reputational harm because the HPCSA prelim committee decisions are held in private. How can you also prove a loss in income and reputational loss where the complaint and the way it's heard is done in a private forum? So that our advice is, yes, there are circumstances where a patient makes a malicious complaint and you can prove that they have done so. But by far and wide, the advice to you is just let the complaint lie. The patient, leave the patient alone. Do not challenge the patient. So myth number 6, I work in the state sector, so I don't need my own indemnity. So the perception that those colleagues who work in the state sector don't need their own indemnity is in fact a myth. If we just look at the statistics here on the screen, which is a proportional breakdown of our work, we can see that claim cases represent just under 1/4 of our work. The non-claims occupy about 75% of our work, and conversely, claims for compensation damages take up 75% of our costs. So claims and damages, low number of cases, high costs, and they are the most expensive to handle, defend, and settle where settling is the only option. So dentists, therapists, hygienists employed by the state are indemnified by their employer under the Treasury regulations. So what this means in practice is that if one of those colleagues negligently harms a patient they are treating in the state sector and causes an avoidable injury, then the patient will sue the state for compensation and not the dentist. Because as an employer, the state is vicariously liable for the acts and omissions of its employees. There are, of course, certain caveats where the state, having settled a claim, can seek to recover their loss from the employee dentist if that individual has been grossly negligent or willfully ignored state policy. In that situation, there is no indemnity for the individual in such a situation. So if we rule out claims, then all the other case types where we provide indemnity apply equally to the state dentist. And by far the biggest risk to the state dentist is either a complaint made to the hospital or clinic where they work or to the HPCSA. So who helps that dentist with the complaint? Well, we do if they're a member of Dental Protection. We give advice on how they should respond to the complaint or an employer investigation of the complaint. Increasingly, if there are performance concerns, employers will refer concerns to the HPCSA nowadays rather than use their own internal disciplinary procedures until the HPCSA have reached their determination. Who supports the state dentist with a complaint before the HPCSA? We do, just like any other member, and we provide you with your own legal representation paid for by Dental Protection. In the event that the patient lists the state dentist as a defendant in a claim, we will also remind the state of their responsibilities to protect an employee on behalf of our member. The state sector dentist who is a member of Dental Protection has the same rights of access to all our risk prevention resources. Our online digital member-only platform, PRISM, gives you access to the same webinars, podcasts, written articles and journals as all your other colleagues who are members of MPS. In terms of price, membership costs are significantly lower than those in private practice pay because we don't defend or settle the claim, because the state has to do that by law. That is the important thing you must remember. So here's another myth. The patient wants a copy of the treatment records, but I don't have to provide them as they belong to me. Well, bad news here, because patients do have a statutory right to access their treatment records under the Promotion of Access to Information Act and soon to be enacted POPI Act. The information recorded in the treatment records belongs to the patient. We are merely the guardians of that information. We may own the paper or the software, but we do not own the information. And it's important when you receive a request for records from an attorney that you contact Dental Protection for advice and assistance before the disclosure is made. Bearing in mind that the full records are disclosable, then it helps if nothing derogatory is written about the patient, as this might cause you some discomfort if the records are shared with the HPCSA as part of a complaint. So remember, keep personal comments out of your treatment records. The second point I want to make about records here is that sometimes the records contain nothing more than ICD-10 codes, and it's only at the point where disclosure has been requested that regrets surface about what you wished you'd actually written in the records at the time. It is incredibly important not to attempt to tamper with the records and rewrite history, no matter how poor you think your records are. Only the original contemporaneous record can be used in your defense, and any attempts to change history or what was written by adding something or deleting something completely undermines your integrity and our ability to defend you. Okay, so we're on to myth number 8. My practice specializes in cosmetic dentistry, therefore it's okay to call myself a specialist in cosmetic dentistry. Well, again, I'm sorry, this myth is wrong. The Health Professions Act makes it clear that you can only register as a specialist and call yourself a specialist if you're registered against one of the nominated dental specialties. The Act also makes it very clear that anyone who holds themselves out to be a specialist when not registered as a specialist is committing an offence. Further bad news, the HPCSA ethical rules clarify that you may only hold yourself out to be a specialist in a certain field of dentistry, which is a registered specialty. And currently, there is no specialty of cosmetic dentistry, and similarly, no recognised and registrable specialty of implantology. So what this means is that calling yourself, including advertising, a specialist in cosmetic dentistry or a specialist in implantology is unlawful and misleading. And until such time as these disciplines are recognised as specialties in their own right, then you can only legally and ethically say you have a particular interest in implantology or cosmetic dentistry, or a practice limited to cosmetic dentistry or implantology. You cannot describe yourself as an implantologist for the same reason, because there is no specialty of implantology to be an implantologist in. So, second but last myth, it's not my problem if the other dentists, therapists and hygienists working for me don't have their own indemnity. Well, I'm afraid that myth is not true. The traditional model of dentistry continues to evolve, and single-handed practices are becoming more expensive to run, increasing overheads and governance requirements. So what we are seeing is practices with more dentists working under one rule. one roof. A skill mix where a number of dentists, therapists and oral hygienes work together as well. And the majority of staff will work as independent contractors, or at least that will be what the arrangement is meant to be. So who is at risk if a patient is negligently harmed by another dentist who works for you, or a therapist or a hygienist when you own the practice? Well, the answer to this question is very much dependent on two factors. The first factor is the patient. Now, from the patient's view, they come to your practice, they pay money to the practice rather than to the individual dentist or therapist. And on that basis, they are more likely to sue the practice because they don't understand the unique relationship where, from a registration perspective, each individual practitioner is meant to be responsible for their own acts and omissions. That is from an ethical viewpoint. However, in South Africa, there is still no legal requirement to have indemnity, and it's quite likely that a patient will be advised to sue a practice, as the practice is more likely to have deeper pockets and indemnity to pay compensation than the individual dentist or therapist. Now, the second point that needs to be made here is that the relationship between the owner of the practice and the patient treating staff who work there is an important consideration. So if an employer-employee relationship exists and the contract of employment states that, then the employer of the dentist, therapist or hygienist becomes vicariously liable for the acts and omissions of those staff that they legally employ. And we've seen contracts between independent contractors and practice owners where the parties to the contract are described as employer and employee, and the contract is described as a contract of employment. True independent contractors will not create a vicarious liability for the owner of the business, but the relationship and what it says in the contract could undermine the independence of the relationship. True independent contractors will be registered provisional taxpayers and run their own business and will invoice the owner of the practice each month for the money they are due. So taking both those points into consideration, a practice owner could be sued for the negligent acts and omissions of the dentists, therapists and hygienists who they work with. This then becomes a problem for the practice owner because their indemnity or insurance is related to their own treatment and not to anyone else's. You are priced on your own risk and nobody else's. So if you are sued for the negligence of your staff, then you may end up paying damages and costs out of your own pocket and then having to sue the dentist or the therapist with no guarantee because they'll say they were an employee. So the key message here is that every practice owner is at risk if they don't insist all their dentists and hygienists and therapists have their own indemnity. It's non-negotiable, and that indemnity should really be occurrence-based rather than claims-made indemnity. The second message is that just because you work for somebody, don't assume the practice is indemnity because it doesn't. So this is a message to all the dentists, hygienists and therapists who work for a dentist who owns the practice. Do not assume the practice has indemnity because it doesn't. All healthcare practitioners treating patients should have their own indemnity. If you are the practice owner, you want that indemnity to be occurrence-based because it indemnifies the incident even after the dentist or therapist or hygienist has left, unlike a claims-made insurance, which they have to continue paying long after they've left you, and you have no control over them doing so. So the key message here is if you're a practice owner, make sure that everybody who works for you, who treats patients, has their own indemnity. If you are one of those dentists, hygienists and therapists working for a dentist practice owner, do not rely on the practice owner having indemnity to cover you either. So my final myth is split into two parts, 10A and 10B. Now, the first one, I shouldn't speak to a patient after an adverse event. Well, that is a myth because we do advocate that you speak to your patients upfront after an error has taken place. And it's the right thing for professional people to do. Being honest and truthful is one of the key fundamentals of our ethical rules. And it's much better if the patient finds out from you that something is going wrong rather than find out from another dentist. Things like acid etch burns, for example, on the lips and skin of the face can cause significant distress if they're not dealt with immediately. Showing empathy and regret that such an incident has occurred is not the same as an admission of guilt. I'm sorry this was not the outcome I expected is not the same as saying it's your fault. There is much to be investigated before any negligence can be confirmed. So if something goes wrong, apologize to the patient. This was not what I expected. This was not the outcome. Do not worry about that being misconstrued as an admission of guilt, because it's not. Distancing yourself from the problem because you're afraid of the consequences is a clear driver for a patient to take further action. In most areas of dentistry, there is always a solution. Take the acid etch burn as an example, then a prompt referral to a dermatologist or a plastic surgeon is generally the right thing to do if the patient's worried about their face. Put yourself in the position of the patient. What would you want or expect to happen if it was yourself or your own family member who was harmed? There's nothing more destructive for a professional relationship to abandon the patient and let them find solutions to their own problems. If a patient needs to see another specialist or a max fax where a root has ended up in the sinus, then make a prompt referral. If the patient asks you to meet the cost, then you should indicate you're willing to make a contribution towards their costs, initially as a gesture of goodwill, and immediately contact Dental Protection for advice and support, or your other indemnifier. Depending on the individual circumstances, your indemnity may well fund the remedial treatment of your patient, and doing so may be all the patient is expecting. Listen, not every patient wants to litigate, and for most, they just want a prompt and fair outcome. Now, this leads nicely into myth 10B. If I ignore the complaint for long enough, chances are it will go away. Well, again, this is a myth. I mean, it could, but it's not a good idea to ignore a complaint. HPCSA ethical rules under duties to your patients place an ethical obligation on all registered practitioners to respond to criticism and complaints promptly and constructively, and whether the complaint has merit or not. Most patients who make a complaint verbally or formally will expect some sort of response, and we're all the same where we have to put pen to paper or graph to an email. We don't expect our complaints to be ignored, and when it happens and we've raised reasonable and genuine concerns, we expect a response. When we don't, we usually become more motivated and focused on elevating the status of our concerns, and your patients are no different. And what they will do if they don't get a response from you is that they will often take the line of least resistance and complain to the HPCSA. That's the easiest thing in the world to do. You just download a complaint form, fill it in, it costs you nothing apart from your time. And when that happens, not only will you have to respond to the complaint, but you'll also have to explain to the HPCSA why you did not fulfill your ethical obligations as set out in Rule 5.1.10. So responding to complaints is not easy, and sometimes our responses are unprofessional and are emotion-based rather than fact-based. You also need to understand that the HPCSA are not going to admonish the person making the complaint. It just doesn't happen, even if the complaint is found to be without merit. I have yet to see the HPCSA prelim committee writing a letter to complainant saying you were wrong to make this complaint. It doesn't happen. So they never say you were wrong to make this complaint, go and apologize to the dentist. It won't be happening. So the key message here is don't ignore complaints. Contact your indemnifier for help in responding to complaints. Our approach has always been to help our members take the subjective, emotional component out of the response when it's needed, and then help them write a professional response promptly with an endpoint in sight. And this endpoint is about what you're hoping to achieve as the best solution to this complaint. We've been doing this for years, and you just need to contact us to ask us for our help. So, Casey, that brings me to the end of my myths presentation. If there are any myths that that our delegates out there can think of, then they can put them down in the Q&A session and we can pick them up as we go along, or do Dental Legal Myth Busting Part 2. So at this point, I'm going to hand over to I'm going to stop sharing and hand over to Yash, and thank everybody for their attention.
Okay, thanks, Alasdair. I'm just going to share my screen quickly, so bear with me for a second while I do that. So, Alasdair, Casey, just confirm that you can see my introductory slide there. Thanks, that's perfect. So I'll then go on, if that's fine. So good evening, everyone. It's good to be here presenting again at another SADA event. I've recently, well, last year actually, done a branch meeting, but not one of these webinars. For those of whom I haven't chatted to before, my name is Yash Naido. I used to be a dentist for a short while before pursuing my passion in the law and becoming an admitted attorney. As Casey mentioned, I was privileged to practice as a healthcare lawyer at some of the continents in the world's biggest law firms. But now I have the pleasure of speaking to you with my dental protection hat on, as I've recently joined MPS in South Africa. Now, dental protection has recently been receiving a number of queries from our members regarding the issue of communicating with peers via social media for purposes of educational study groups, mentoring, clinical advice, and the like. Now, this evening, I'm hoping to cover just some of the ethical and legal implications of and the risks involved in the use of social media by dentists, with a slight slant towards the context of clinical mentoring. Now, I'm going to be upfront with you and say this. I know that us lawyers can sometimes have a tendency to give the impression that we know everything about the law and what we tell you is textbook advice. And a perfect example that comes to mind is what Alasdair might have touched on a bit earlier, and that's advice I often hear being given to or repeated by some practitioners and some so-called medical legal experts, that you should never apologize to a patient as this amounts to an admission of liability. Never do it, they say. So firstly, as we've heard, that's not necessarily the right advice. And secondly, I'm not one of those lawyers. I definitely don't have all the answers. And I'm comfortable saying that. It would be impossible to have all the answers. And this evening, my hope is not to pretend that what I'm telling you is the hard and fast rules of the game, because it can never be. There'll always be case-specific considerations. Instead, my hope is to create awareness about the law and the ethical guidelines and what they say, so that you, as the practitioner, can be empowered in your decision-making. At the end of this talk, we might have an opportunity to answer some of your questions, and I've been furiously typing away trying to answer some of your written questions. But remember that as a dental protection member, you're entitled to request dental legal advice from us, and we encourage you to write in and ask if you have any queries. As I said, often the advice will depend on the specific circumstances surrounding your query and will probably require tailored advice. So anyway, with all that said and out of the way, on your screen, these are the 3 topics I'm hoping to cover this evening. Firstly, what does the HPCSA say about the use of social media? Then we'll look at what the duty of care is, who has the duty of care, and why the use of social media can potentially blur the lines between mentoring and telehealth or teledentistry. And then lastly, we'll refresh ourselves on what the law and ethical rules say about consent and confidentiality. And on that topic, we'll just touch the tip of the iceberg of the latest data protection law, which has come into effect in the country, known as the Protection of Personal Information Act, commonly known as POPI. And for our Afrikaans-speaking members, I can assure you it has nothing to do with a pretty woman, but we'll talk about it a bit later anyway. So our regulator, the Health Professions Council of South Africa, the HPCSA, as you all have seen on their website, is proudly tasked with guiding the professions and protecting the public. And as most of you will know, the council has on its website a number of these so-called guideline booklets. Now, I'll just pause there to mention that only one of these booklets is technically incorporated into our law by means of publication in a gazette, and that's the ethical rules booklet. The other booklets are simply what their names imply, guidelines, but that's as technical as I'm going to get for purposes of today's discussion. the important thing for you to know is, firstly, these books actually exist and can be found on the HPCSA's website, admittedly with a little bit of digging because it's not as user-friendly to get in and find them. But secondly, you should, as a registered HPCSA practitioner, familiarize yourselves with the contents of the guideline booklets. Now, I'm not saying memorize them because I don't even have them memorized, but just know that there's guidelines there and what, briefly they say. And then lastly, and most importantly for this evening's discussion, the HPCSA's most recently published booklet 16, which is known as the Ethical Guidelines on Social Media. Now, it's a 15-page document, and I'll leave the bedtime reading for you to do. I just wanted to highlight a few important and relevant points in this booklet for this evening. But you'll see, however, once you've read the entire booklet, that much of it is simply guidance which any member of society should take into consideration, not just necessarily only us healthcare professionals. It's the type of common sense stuff which, we always say is often not so common. Things such as don't make racist or sexist comments online. That's in the booklet. Or remember that everything you say online lasts forever. Or the other one is that nothing you say is really anonymous, even if you post it anonymously in a group. So anyway, the first really important piece of information that I thought I must share tonight is, what does the HPCSA reckon social media actually is? Now, I've quoted from the booklet, and hopefully I've given you enough time to read it and digest it on your screen, but I'll read it out nonetheless because it's important. So it says, social media includes social networks, for example, Facebook, Twitter, and LinkedIn, content sharing platforms, for example, YouTube and Instagram, personal and professional blogs, internet discussion forums, and the comment sections, the infamous comment sections of websites. Now, most of you will probably agree with what's up there on the slide, but I suspect that some of you who have either looked into the subject more deeply or simply more tech savvy than my old man might notice some key omissions there. And that's because actually I've left out some of the wording on purpose. And not to trick you, because I'm not here to trick you, but I wanted to highlight some important points. So firstly, I've left out a platform which I think anyone who knows a little bit more than the average person about social media will know is an obvious omission. And then secondly, I've left out a few platforms which I think might surprise you, because I know when I read them in the booklet, they surprised me. So the first platform I'm talking about, of course, is WhatsApp. So yes, the HPCSA, and I think most will agree, regards WhatsApp as social media. But then there's the less obvious ones which I've left out on purpose and which the HPCSA regards as social media, and I'll list them on the next slide. So firstly, we've got WhatsApp there just for completeness sake, but have a look at these emails. Surely that's private. And then what about SMS and electronic journals, as well as those published anonymously? Now, a lot of you, and I must confess I was in this boat myself, might scoff at these examples. Then I thought about it and I gave it some more consideration, and I can only conclude that when the HPCSA refers to emails and SMSs, and when those are concerned, this probably involves a situation where the communications are made to many people. So the SMSs are bulk SMSs or bulk emails. Essentially, what I think it is it's the publication of information, and not publication in that technical sense of publishing it in a book or something like that, but it's making information publicly available, that sense. So that would also probably explain why electronic journals are included in the definition. Personally, I've never seen a journal article as anything but social. In fact, I'm sure if many would think if I had to whoop out a journal article this evening or during the holidays and read it, people would think I'm being antisocial. But I presume that's what the HPCSA is getting at when they talk about publication of information in electronic format. But I want us to remember this: whatever the explanation is, and whether in fact it's right or wrong in theory, we must always remember one important thing. And that's, if a complaint ever goes to the HPCSA, one of the main things they'll look at when judging our conduct as practitioners is whether their guidelines have been complied with or not. So let's for the moment forget about arguing whether or not electronic journals are social media, and just always bear in mind that according to the HPCSA, at least, they are social media. Now, next slide is, I know it's a bit of a sin for presenters to flood their PowerPoint slides with lots of text, but I hope you'll forgive me, because in this case, I thought it was crucial to do so, just to highlight a particular point. I'm going to read some paragraphs in the booklets and then explain the point I'm trying to highlight. So the HPCSA says the following, and I'm going to read: health practitioners may find social media beneficial as it allows them to keep updated on the latest healthcare developments through reputable user-generated content, or build a professional support network, as well as communicate and share health-related information with the public and other health practitioners. So that's situated this is in their booklet, their social media guidelines. But a few paragraphs later, this is what they say: obligations relating to the electronic storage and transmission of patient and client data for professional purposes are found in booklet 10, General Ethical Guidelines for Good Practice in Telemedicine. So why am I drawing your attention to these two specific paragraphs? Now, I'm doing this to shed some light on a topic which I briefly mentioned earlier in my introduction, and that is the blurred lines between the use of social media for mentoring and how we as practitioners risk stepping into the realm of telemedicine or teledentistry, depending on how we use the social media. So if one looks carefully at these quoted guidelines in the context of the entire social media booklet, what it seems to me the HPCSA is telling us is that if you're sharing health-related information with other practitioners for purposes of keeping updated on the latest developments or for building a professional support network, then that's probably not teledentistry. But the moment you're sharing your patient's data for professional purposes, so trying to figure out what you should do next or what's the diagnosis, then that probably is telemedicine or teledentistry. And in that case, the telemedicine guidelines will apply. So this talk this evening is not about telemedicine, not about telehealth, teledentistry. So I'm not going to get into the details on that. But I will touch on it a bit later when I discuss the duty of care. And we will then look at what the guidelines, the telemedicine guidelines, say when we get there. So let's move on now to the so-called duty of care. Now, in South Africa, it's probably more appropriate to call it a legal duty instead of a duty of care, because that's more of a UK term. But again, without getting technical, the duty of care is simply this: it's the duty which a dentist has towards their patient to prevent their patient from suffering harm. That's in a nutshell what legal duty or duty of care is. So, usually I'm sure we can all agree that it's not complicated to figure out whether or not you have a legal duty towards your patient. When they walk into your rooms, either self-referred or referred by a colleague, you examine or treat them, you accept them as your patient, and by implication, you accept that you have a duty to treat them and prevent them from suffering harm. That would be a no-brainer situation. But what about patients who you don't see, who you don't directly treat? Surely you're thinking, there's no doctor-patient relationship, and therefore you have no legal duty to prevent harm. Well, unfortunately, that's not correct. So in South African law, there are other factors which, if they are present and applicable to a specific case or a specific patient, can actually mean that you have a legal duty towards the patient. So what are these factors, or some of them at least? Now, these are things like prior conduct. So prior conduct: did you create a new source of danger by means of your prior conduct and then fail to eliminate that danger, resulting in subsequent harm to the patient? Prior conduct such as this is a strong indication that you had a legal duty to prevent harm to the patient. So let's look at it in the mentoring context. Let's say you're an experienced implantologist and you're the mentor in a group, and you advise an inexperienced GP dentist on where to place an implant in their patient, knowing that there is a risk to the patient in the circumstances, and that the dentist acts on your advice and causes harm to the patient. It may then be argued that by your conduct in advising the inexperienced dentist, you, as the mentor, created a source of danger to the patient which you failed to eliminate. So then you would have had the legal duty to prevent harm, and you didn't. and your actions were therefore wrongful in our law, or unlawful is what they call it. So there's also another more obvious potential factor which would show that you have a legal duty towards the patient. And it might sound very simplistic, but I'm going to tell it to you anyway. It's when you have a contractual agreement with another dentist for the safety and well-being of patients. So let's, for argument's sake, say that you have this mentoring group again, and for some reason you agree with the dentists who are your mentees that when giving them advice about their cases, you will take steps to ensure your advice doesn't harm their patients. Well, then clearly you're under a legal duty to ensure that that is done. So in that situation, if a dentist acts on your advice and the patient suffers harm because you've not taken steps to ensure there was no harm, you may actually have breached your legal duty to the patient. And remember, a contractual agreement doesn't necessarily have to be in writing. It may be implied. So just because you don't have something like this in writing with your mentees or your mentor, it doesn't mean that it can't be argued by your mentees or even the patients at a later stage that an agreement like this existed. It might be implied by conduct, and there would be an inquiry into that at a later stage if legal action were to ensue. So there are many other legal principles which are quite complex and which can be applied to determine whether or not a legal duty is owed to another person to prevent harm falling on them, not just a patient and a doctor. But these examples I've mentioned should, I hope, make it clear that it may actually be easy to breach a legal duty towards a patient without even knowing you owe the duty to a patient at all. So this must be kept in mind whenever you're a mentor or even a mentee in one of these social media groups. Now, I said I wanted to touch on telemedicine or telehealth earlier, and this is the moment I wanted to bring it up because this is the most relevant context, most relevant to the context of social media, mentoring via social media. So let's say that in the process of your mentoring via social media, you as the mentor advise your mentees on how to go about treating specific cases. You don't consult with the patient yourself. You simply look at photos and x-rays, discuss the history of the case with your mentee, and give advice specific to that patient. Your mentee then acts on that advice, and your mentee wouldn't have done this to the patient without first consulting with you as a mentor. Now, while I speak and while I give you that hypothetical situation, I'm hoping that if you're reading the text on the left-hand side of your slide, of the slide on your screen, you'll see that this type of arrangement seems to fall squarely under the definition of telemedicine. And this definition I've taken straight out of the HPCSA's guideline booklet on telemedicine, which is booklet 10, if you want to go look for it. And that says, and again, I'll read, telemedicine is defined as the practice of medicine using electronic communications, information technology, or other electronic means between a healthcare practitioner in one location and a healthcare practitioner in another location for the purpose of facilitating, improving, and enhancing clinical, educational, scientific research, particularly to the underserviced areas in the Republic of South Africa. So I'm not ignoring the fact that the HPCSA has, for the period or the duration of the pandemic, amended this definition of telemedicine. And I've put that amended definition on the right-hand side for completeness sake. So the amended definition does away with the need for the setup of two practitioners. It actually allows telehealth in the more obvious sense that we would think of it. So that's a patient consulting directly with a practitioner either by telephone or virtual means. But we must remember that the remainder of the guidance in the telemedicine booklet is still in place. And in any case, the scenario that I just mentioned will still qualify as telemedicine or teledentistry under the new temporary definition. So it doesn't mean now that because the definition has been temporarily amended, that it doesn't include situations where there are two practitioners. Actually, the amended definition broadens the scope of telehealth as opposed to restricting it. So it will still apply. So what point am I trying to make? Firstly, I was talking about duty of care. So who has the duty of care towards the patient? Is it the dentist who sees the patient face to face? Or is it the dentist at the other end of a computer screen? The HPCSA's guidelines tell us something about a thing called the assumption of primary responsibility. So who has the primary responsibility towards the patient, according to the HPCSA's guidelines. They say the following: the consulting practitioner, and I've put in brackets, that's the face-to-face practitioner, that's the mentee, remains responsible for the treatment, decisions, and other recommendations given to the patient, as well as for keeping detailed records of the patient's condition and information transmitted and received from the servicing practitioner. Again, in brackets, I've put the mentor in our scenario. The serving practitioner, that's the mentor, must keep detailed records of the advice he or she delivers, as well as the information he or she receives and on which the advice is based. And then the servicing practitioner, that's the mentor, must further ensure that the advice or treatment suggestions given were understood by the consulting practitioner, that's the mentee, or the patient. So because the wording assumption of primary responsibility is used, this doesn't mean that the servicing practitioner, that's the mentor, has no legal duty towards the patient. You know, the HPCSA says the relationship between the patient and the healthcare practitioner is established when the practitioner agrees to treat the patient and the patient agrees to be treated. So once this has been established, there is, in my understanding, a doctor-patient relationship between the patient and both practitioners, not just the one or the other, and therefore a legal duty on both the consulting and the servicing practitioner to prevent harm to the patient. And the HPCSA reiterates this by including in its guidance the mention that servicing practitioners, that's the mentors, are held to the same standards as those who conduct face-to-face consultations. So they make it pretty clear with that wording. And with that, I'm going to move on to consent and confidentiality. Now, I'm not going to go over the usual principles of consent, which you've probably would have heard of time and time again, and which by now I suspect should be second nature to most of you. For this evening, I'm only going to touch on those rules and principles relating specifically to the setup of mentoring by social media. And even then, not all the rules, but just the important ones for tonight. So the National Health Act says a user, that's a patient, has the right to participate in any decision affecting his or her personal health or treatment. So in other words, if my dentist is going to be seeking advice from a colleague regarding my treatment, I have the right to, as a patient, to participate in that decision. I should be informed and expressly consent to it. I might want to, for example, decide to visit that other dentist directly myself. That information might actually make me want to reconsider whether I want my treatment done by the dentist I'm currently seeing. For whatever reason, I might think, well, look, if she wants to consult somebody else, why don't I just go straight to them? Or I'm not confident in their ability. So it's crucial that I, as the patient, be informed of this so that I can make a decision which affects my health treatment. And that's what the National Health Act says needs to happen. Then POPI tells us that processing of information, and remember, processing means anything from collection, storage, transmission, even destruction of information. So in other words, almost everything we dentists do with patients' health information. The processing of health information, and that's also been given a higher rank in POPI, it's called special personal information, that's prohibited. However, and I can see alarm bells now ringing, but I wanted to say this, however, it is allowed if the patient consents to it. And then there's the caveat in POPI, and which one of our panel attorneys calls the silver bullet, or sometimes jokingly, the get out of jail free card. And that's section 32 of POPI, which says that the prohibition on processing of health information does not apply to processing by medical professionals if necessary for proper treatment and care of the patient, or for the administration of the institution or professional practice concerned. So that's what we do generally as dentists. We process information for those reasons. But then importantly, POPI also says that personal information must be collected for a specific, explicitly defined purpose relating to the function or activity of the practitioner. And further, that the practitioner must ensure that the patient is aware of the purpose of the collection of the information. So if you're going to be taking intraoral photos for purposes of sharing with your mentoring group, you must explicitly say so to your patient, and your patient must agree to this happening. And then the HPCSA on consent, it says that practitioners should ensure that patients are aware that personal information about them will be shared within the healthcare team, and patients must be told reasons for this. So that's in the normal course of treatment, not talking about mentoring and social media. But as far as social media is concerned, the HPCSA then goes on to say that written consent must be obtained from the patient before publishing information about them in media. So it's not even saying social media, in media to which the public has access, whether or not the practitioner believes that the patient can be identified by the data. So if that photo, even if you think the patient can't be identified, you need written consent according to the HPCSA. So you must get written consent to share even de-identified photos of your patient to your mentoring group. And then confidentiality is a principle which I know we are all familiar with as healthcare practitioners. We know that information shared between doctor and patient is confidential, and POPI hasn't changed any of that. It actually just reinforces the principles which we've been putting into practice over the years. The one interesting point in this slide worth mentioning is what the HPCSA says again in its social media booklet, which I'll read. It's health practitioners sharing information or data for diagnosis, treatment, or education through social media must ensure the recipient of the information is not able to identify the patient. I mean, let that sink in. And I'll get back to the point of de-identify information shortly, because POPI has an important provision in that regard. But when I read this HPCSA provision, it just reminds me of what I sometimes see on Instagram or Facebook, and I wonder at the back of my head. I'll often see photos of patients, with before and after treatment, and sometimes I'll just see the patient's eyes are blacked out and the rest of the face and the neck is visible. Now, I don't know about most people, but I can bet you if you put a photo of me on the internet and block out my eyes, just block out my eyes, lots of my friends and family are going to recognize my big nose and my funny hair, which is getting grayer by the minute, and my increasingly growing double chin, and they'll know it's me. So, if that's done, if somebody puts that kind of photo of me online, technically, whoever has put that photo of me online has not ensured that recipients can't identify me. And the person who shared that will be contravening the HPCSA's guidance. But we'll get back to de-identifying information a bit later. But continuing with the topic of confidentiality, as I said, POPI doesn't really change anything, but it merely codifies the principles we already know into law. So you, as the practitioner processing the patient's information, must take reasonable technical and organizational measures to prevent loss, damage, or unauthorized access to that information. So, the general stuff. If you have hard copy files, keep them safely locked away. Make sure your receptionists are trained not to inadvertently speak too loudly about patients' personal information, which might be overheard by others in the waiting room. This is something I've personally experienced while waiting in a doctor's waiting room. And then more relevant to today's talk, keep your devices secured, proper passwords, always on the latest software. Update that software. Have an up-to-date antivirus software if you can on your computers. And then regularly check and maintain all of these things. The question pops up, what happens to information or photos or anything like that that's shared on a WhatsApp group? What is stopping people in the members of that group? I understand it might be a closed group, but what's stopping them from just simply pressing two buttons and taking the screenshot and sharing it with anyone else? If that happens, that would be a breach of POPI security. It would be a breach of confidentiality, and there's a whole minefield that opens up. But anyway, as I said, it's always been what we've been told and guided about, these confidentiality measures, but now it's in an official piece of legislation. Then coming back to the point of de-identifying information, I wanted to look at what POPI says, and this is what POPI says. It says de-identify means to delete any information that identifies the patient, can be used or manipulated by a reasonably foreseeable method to identify the patient, or can be linked by a reasonably foreseeable method to other information that identifies the patient. So luckily for us dentists, I think generally an intraoral X-ray or a photo arguably is de-identified. You can't tell who that is just by looking at the X-ray or periapical. But what about the perioral photo of a patient who has, for example, a very distinctive tattoo or mouth piercings, or it's that photo of Yash with a double chin? If that could, by some reasonably foreseeable method, identify the patient, then that photo is probably not de-identified. And this is important because POPI doesn't apply to information which has been de-identified to the extent that it cannot be re-identified again. So if it's properly de-identified, then POPI doesn't apply to it. But remember, even if that's the case and you've gotten out of it in terms of POPI, we still have to remember what the HPCSA's rules and ethical guidelines says, and that it still applies. So it's not exactly, in this case, a get out of jail free card if you do de-identify the photos. You still need patient's consent in terms of the HPCSA's guidelines before you publish them. So yes, I've given you a lot of food for thought this evening, I hope. And I appreciate that it can be overwhelming, and that's because it is a lot of information and it may sometimes feel like we're all over the place. So I thought let's recap and look at what we've hopefully learned today. So firstly, we learned what the HPCSA regards as social media. And remember, this includes WhatsApp, emails, SMSs, and those very sociable electronic journals. Secondly, we spoke about what the duty of care is, and we saw that the duty of care extends to a practitioner sitting on the other end of a computer or cell phone screen in the teledentistry context. We also saw why the mentoring setup, if not done carefully, might end up giving practitioners more legal duties, obligations, and risks than what they initially bargained for. And lastly, we looked at the legal and ethical principles of consent and confidentiality pertaining to sharing of patient information by social media. So what are the points I would like us to take away from this presentation if we don't take away anything? So it's this, it's that social media is actually recognized as having a place in the space of education, information sharing, diagnosis, treatment planning, etc. So it's not prohibited and it can be done. However, when it is done, or if it is done by practitioners, there's a ton of legal and ethical considerations that come into play and need to be borne in mind. For me, I think the most important thing to remember, even if you're not contemplating this kind of setup, the most important thing to remember is that as practitioners, we're legally and ethically obliged to act in our patients' best interests, involving them in the decision-making regarding their treatment and getting their informed consent to any proposed interventions. So, sometimes the patient's best interests and our clinical competence or incompetence or inexperience dictates that we have to refer them in their best interest to more experienced colleagues. Even that referral process must be discussed with and agreed by the patient. And whether that referral is in the form of advice sought by mentoring groups or actually referring the patient on physically, informed consent must be obtained from the patient. So in closing, yes, there is definitely a place for these types of groups, be they on WhatsApp or other forms of social media. We just need to make sure that if we engage in them, we do so lawfully and in compliance with what our regulator prescribes. And with that, Casey, I think I'll hand back to you, Mr. President. Thanks a lot. Stop sharing.
Thank you very much, Dr. Naidu. Thank you for calling me Mr. President, but you're gonna make me fight with the president of the association, Dr. Ronen Naidu, or you'll make me, yes, or you make me fight with the president of the country, Mr. Cyril Ramaphosa. So I'm the CEO.
Oh, my apologies, Mr. CEO. Thanks. Sorry about
that. We have gone slightly over time to the attendees, but there are quite a few questions on the Q&A sections, which I think are pertinent. And I do apologize. I'm going to allow these questions that we take the key ones. Some of them we can actually club them together. And Alasdair has already been looking at those. Some he will answer directly, and some he will hand over to Yash, or maybe they will collaborate. But before we do that, we are having 521 registrants. We were at some stage 531. I would like to do the winning numbers for now, for the two hampers that we spoke about earlier on. So I'm going to start with Yash. If you can choose any number between 1 and 521, any number, please, for me, Yash.
And I can say it out loud, right?
You must say it loud, yes.
It's 5, my favorite number.
5. Okay. Now that you have chosen 5, Alasdair, you have to choose a 2-digit number, as well as yourself. It must be a number between 1 and 521.
But only a two-digit. Only a 2-digit number.
Sorry. So I do apologize. It has to be. Sorry, it must be 2 or 3 digits since we go to 521.
Okay, Casey, I am going to choose the number 301.
301, so 5 and 301. These numbers will represent the winners, and we will identify them, and we are going to announce them tomorrow. In the meeting, please come in to know if you are the winner. These are good stuff we have. Without further ado, Alasdair, I'm going to hand over to you. My suggestion is look at similar themes, and if you can answer those questions together so that we don't go line by line, so that we do not take more. It's now nearly 25 minutes past 8. So we are over time, but I'm going to hand over to you to see how you can best deal with the questions that are online. Thank you, Alasdair.
Okay, thank you, Casey. I mean, there's a number of questions come up about the vicarious liability of a practice owner, and we've got one here. What happens if a patient presents with a complaint about a procedure done by a dentist in your employ after the dentist has left your employment and is not on dental protection anymore, but he was while in your employment? Okay, so I'm kind of paraphrasing the question here, but what happens if a patient complains about treatment that was carried out by a dentist who's no longer working for you? Okay, so what you have to do is that you have to refer the complaint to the dentist. Okay, so your job is to manage the complaint and make the dentist aware that there is a complaint if you've got a contact for that individual. Okay, the second thing the patient can do is the patient can be encouraged to use the SADA mediation process. If the patient complains through the SADA mediation process, then Dr. Bernard will contact the dentist, whether he works for you or whether he works somewhere else. His name will be on the HPCSA register, provided he is registered. Okay, so those are the things that you must do. Now, if that dentist had an indemnity with dental protection at the time he was working for you, providing he was paying the correct grade of membership, then he will be entitled to ask us to help him. So what you should be doing is you should be saying to the dentist, look, we've got a number of complaints. I'm going to send them to you. Can you manage them with the patient? Maybe you need to take some advice from your indemnity provider. That's how I would suggest you deal with it. And if the individual dentist is contactable but unwilling to do anything about it, then you must say to the patient, I've tried to get the dentist to deal with your complaint. The only other avenues you can use are SADA mediation or HPCSA. So that's how I would deal with that question. There was a question here about ethical numbing. I did that in a talk earlier on this summer. I'm not going to go to that one. There's a number of questions for you, Yash. There's one here from a delegate. Dr. Naido, I have a blog on WordPress called youarewithinthenorms.com. We often discuss challenges to dentists during the COVID pandemic, and we further discuss subjects on the responsibility of all practitioners in prescribing narcotic analgesic medication. My blog is licensed in the USA, and all my publications appear on Facebook and Twitter because I have an account with these platforms, and they are also seen all over the globe. Would my blog be considered telemedicine? Is it social medicine? And does it violate the HPCSA? Well, I think we'll start with the HPCSA at the end. If the delegate who asked this question is still registered with the HPCSA, then if they were unhappy about the ethics of his conduct or any aspect of the way he's processing data or opinions, they would hold him accountable. So I can answer that bit. Yash, are you able to talk about whether it would be considered telemedicine or social media?
Well, look, it's on, I believe, was it Facebook, Alasdair?
Yeah, Facebook and Twitter.
Facebook and Twitter. If it's on there, it's on social media.
Yeah.
But the question arises, are you publishing patient-related information? And is somebody on the other end of the screen in the US acting on that information? Are you giving advice in relation to specific cases? And remember what I'd said earlier, and what the guidelines say, is that if you are publishing information to build your professional network, and if you are trying to keep updated the latest developments, it's probably not going to be telemedicine. But the moment you cross that line and it becomes a situation where the practitioner at the other end is acting on the advice that you're giving, there's a potential for it to be telemedicine. But without having further information, we wouldn't know the answer to that. And we'd have to get more details.
So I think the deciding factor is whether it's talking about dentistry in general or whether the conversation's about the treatment of a specific patient. And I think that's where you make the difference.
Yeah, and there was a sub-question or sub-part to that question, I can't recall now, but it had to do with...
Let me go back to it. Is it social media? Well, it is social media because it's on social media. So that's a good one. Casey, are there any other questions there that you want us to pick up?
No, I think on the social media you have covered. There's one question that I think maybe you can deal with. We can come back to them. One person asked, says, understanding what you have just presented today, the independent contractor template that SADA has got on its website, then it may be flawed. So maybe you can have a look at that template if you are not aware of it, Alasdair, and have a discussion with Pankaj.
Yeah, I can take that offline, Casey. I think the reason why I wanted to talk about the VL thing was the vicarious liability, is that we're seeing, increasingly, we're seeing patients through their own attorneys suing practices. Okay. Yeah. Now, what happens when they sue the practice is that they're suing the owner of the practice. And you think, how can I be sued if I haven't put my hands on the patient? And that is part of the problem, because normally the patient will sue the dentist who carried out the treatment. But we have this problem of trying to define the relationship between the treating dentist and the practice owner. And I think that vicarious liability is becoming a problem, not just in South Africa, it's a problem in a number of jurisdictions we operate on. And the problem we've got is that the practice owner, the indemnity the practice owner has is only for his or their own treatment acts or omissions. It does not extend to insuring or indemnifying them if a patient sues them for treatment carried out by somebody who worked for them in the practice. And it is that employment relationship that is key. And I think that what we've got to do is we've got to be very clear about whether we're employing dentists or whether we have independent contractors working for us. So there's a subtle difference in the contract that would exist. And one is a contract of service, which is the employer-employee relationship. And the second one is a contract of service, where an independent contractor agrees to work in your practices. They pay you a license fee, which is essentially what you deduct from them. But it creates some some sort of clear water between what the relationship is. Now, if you work in the state, the state employs you, therefore the employer is liable for the acts and omissions of an employee. If you work in private practice and you employ dentists to work in private practice under an employer-employee relationship, then you are, in the eyes of the law, accepting responsibility for the failings of those dentists. So it is incredibly important nowadays to make sure that everybody who works in your practice everybody who's treating patients has their own indemnity. That is the key to all of this. And as a practice owner, the message is very, very important. Anyone who provides treatment of patient in your practice, make sure they've got their own indemnity, because if they have their own indemnity, then this problem is lessened about vicarious liability, because what the practice owner can then say to the lawyer, look, the dentist who carried out the treatment is the person who's responsible for this. I didn't see the patient, and in any event, that dentist has their own indemnity or assurance that will cover the injury in the event. So that's the key message.
And then another maybe concept that I would like you to quickly sum it up is got to do with the assistance of MPS on a legal basis to the member. The question is, how long does it take from once a member has lodged a complaint to say, either I've been contacted by the patient or I've been contacted by the lawyer of the patient? What is the turnaround time from an MPS perspective? Can the doctor wait to get your assistance before they respond to the patient?
Yeah, I mean, what we see in a lot of the letter of demands is that the letter of demand, the patient goes to the attorney, they send in a letter of demand saying they want an astronomical sum of damages and it must be paid within 10 days. Okay, now that 10 days is not legally binding. It's the service or the issue of a summons against the dentist that causes the time frame problem. So if you get a letter of demand from a patient, from an attorney representing a patient, then what you do is you get in touch with us either directly through inquiries at Dental Protection, or you go through the normal channel, which is to contact Ruth at SADA, tell her what the problem is, and then she will forward on the information that you send her to Dental Protection. Now that we've got our own team in the ground, including Yash, we can respond to this sort of thing very, very quickly. But if you don't respond to a letter of demand within 10 days, I don't expect there will be no finding made against you, and you will not be ordered to pay the money.
All right. There are two questions that I would like you to maybe tackle together. They're not necessarily linked. The first one is, please, can you re-explain the concept of ethical numbing that you introduced in one of the lectures, Alasdair? And then maybe the two of you can deal with, am I allowed as a dentist, or is a dentist allowed to video or sound record a difficult patient to avoid this type of you said?
Yeah, can we pick up the second one first? Which is the recording, and Yash can maybe come in here as well, is that I can't wait for the day that there are digital solutions that record interactions between patients and dentists, because that will simplify all of this problem. The problem's twofold here, and I'll very quickly say, one is getting the patient to agree to it, and the other is the processing of the recording and the fact that it becomes part of the treatment record. How long do you have to keep that recording for? So maybe Yash can pick that part of it up for me.
Yeah, let me just unmute quickly. So in principle, there's nothing wrong with recording in principle, but the patient needs to be aware that the consultation is being recorded and agree to it. And the most important part, and the difficult part to comply with, is how do you keep those recording, physically safe somewhere? Because as they said, that's part of the patient's clinical records. So, in my view, an audio recording is actually a better way of recording a consultation. The difficulty is how do you store it? If you can store it safely and ensure that an unauthorized person doesn't access it electronically or otherwise, and the patient agrees to it, and by all means do that. And sometimes patients will ask you the other way around, can I record? And likewise, I don't think there's anything wrong with it, as long as there's proper measures in place to keep that safe.
All right. I'm going to finish off with the next two questions.
Did you want me
Yash,
to? Did you want me to talk about the ethical fade, Casey?
Oh, yeah. Sorry. We skipped that.
I mean, I was just trying to think about what's the best way of explaining it. It's a kind of subconscious bias, is that you stop seeing the ethics in the decision, and the more you make the more you do something that's unethical and get away with it, the more normal it becomes. So, an example would be in soccer, for example, the ball goes out and it's the throw-in. You will never see the guy taking the throw-in take it from the point where the ball went out. They always cheat and get an extra 10 yards before they throw the ball back in. And we've seen this for so long now that it's become the normal, that you don't take the throw in from the pace the ball goes out, even though that's what the rules say. You take it from 10 yards further up towards the opposition's goal. And it's the same thing in golf. You know, golf is a game a number of the delegates will play, and they'll understand that one of the cardinal sins of golf is cheating, is moving your ball. Now, there are some people who will move their ball the very first time into a better lie. Nobody's noticed. They get away with it, and they're relieved, but they say to themselves, I'll never ever do that again if I find myself with a bad lie again in the rough. But the next time it happens, they do the same thing and get away with it. And the more they do it, the more normal it becomes to them. And the more they lose sight of the fact that they're cheating themselves and everybody else. And dentistry is a bit like that. When you're faced with ethical decisions, the more you make an unethical decision and get away with it, the more numb you become to the fact that there is an ethical decision to make, and if nobody picks you up on it, you will continue to do it, and it actually happens subconsciously. It's not a conscious decision.
All right. The last two questions I want us to tackle before we end. I think this will go to both of you, but maybe from Yashin first. Is the HPCSA guideline equivalent to regulation? In other words, can a medical scheme refuse to pay because the ethical guideline says different to what the dentist might have actually done? But maybe link that to the issue of POPI, Yeshin, in that they're asking, when we do write, or when doctors write the medical certificate, should they be using general layman terms, or should they be using the exact diagnosis? And if it's the exact diagnosis, is that not breaching confidentiality?
It's a good question, the one about distinguishing between the guidelines and the laws. Remember, in South Africa, we have legislation, which is commonly known as acts. We have the supreme law of the land, which is called the Constitution, and no other legislation can be in conflict with that. But then we have acts such as the Health Professions Act, the National Health Act, which holds quite strong weight in courts. And then we've got regulations which come underneath that, and those are published under the Gazette. And I mentioned in my talk that only one of the guideline booklets of the HPCSA has been published as a Gazette, or in the Gazette, and that's booklet 2, which is the ethical rules. So, you know, technically speaking, that guidance booklet holds the highest weight in our law, technically speaking, but there have been conflicting views in our courts. So when these actually end up going to court, some high courts have said that the guideline booklets are just simply guidelines and the court doesn't really need to follow that. The court must follow the legislation such as the acts and just take into account. Other judgments have said that the guidance booklets need to be followed substantively, and if you don't follow them substantively, then you're in trouble. What I can say is, and I always say this to dentists and doctors, is that if there's ever a complaint that goes to the HPCSA, the first thing the HPCSA is going to look at, or one of the main things, is their guidance booklets. So try as best as possible to be in line with that, even if sometimes you will find conflicting legislation, such as maybe the Medical Schemes Act, etc.
Thank you. And maybe, Alasdair, the second question on medical certificates?
Yeah, with the medical certificate, presumably, I mean, Yash is going to help me out here, but presumably the medical certificate is given to the patient, who then gives it to their employer. So that it is the patient giving the information to the employer, not the dentist giving confidential information directly to the employer. But the patient's got to decide it will be part of an employment contract that if they are off sick, that the sick note has to contain some details, some very prescribed details about what the employer needs to know about the reason for being off sick. So it's about how much detail you go into, Yash.
Yeah. Before Yash maybe comment, sorry Yash, can then the patient, when they look at that medical certificate, if they're not comfortable with what you have written, can they ask you to change the terms that you have used on a medical certificate?
I mean, I would say they can, but I mean, you have to write the facts, the truth. So if the patient says, "Look, Casey, I know I had a tooth pulled out, but can you say I had 6 teeth pulled out?" That's not going to work. But Yash, you'll know better how sick notes work in your country than I will.
Yeah, so sick notes and even medical reports. So let's just say a patient comes to you as a dentist and says, "I want a summary of my treatment," and the practitioner then gives the summary or a sick note or whatever. If the patient sees something that's factually incorrect in that document, the patient can ask the dentist to amend that and put the correct facts in. But a patient cannot ask you, and you're not obliged to change anything which, in your professional opinion, doesn't apply. So going back to the sick note issue, that would, again, as Alasdair said, depend on how much confidential information the patient is comfortable with disclosing to their employer. But I would always say that if you're drafting a note or a report that is going to be read by a lay person, you should, as often as possible, use plain language that can be understood by and not misinterpreted or misconstrued by the lay person reading it. So I'd always say try and do plain language if possible. Yeah.
Thank you. I think I would like to conclude it here. Final words from you, Yash, in 2 lines.
No, thanks very much, and I hope you enjoy the rest of the week. And good luck to the raffle draw person or the 2 people who ever win it. Good luck.
Thank you very much. I hope you've chosen me, Yash. Thank you so much. Dr. McKelvie?
Yes, thank you to my co-presenter, Yash. I know a lot of work goes into these presentations. To you as always, Casey, my friend, great to see you. Thank you very much for giving us the privilege of opening your Education Week. If the winner is my number 301, that is the room I always stay at in the hotel just outside the Gautrain station in Rosebank. So that's why I chose that one. They always seem to give me the same room number, 301.
Oh, wow.
301.
Oh, wow. That's your lucky number indeed. Yeah. Thank you so much. I want to thank to all the attendees that are still with us, 472, down from the 531 that we reached. I really think this was a useful opening of our conference, or our taste of the conference. There's quite a lot of questions that you guys have asked. I will speak to the speakers. I think there may be another way that we can publish our answers on this. But I will speak to them, and if they agree to my suggestions, you will probably see these questions with some answers in another platform. Thank you so much, and thank you to my speakers, and thank you to all of you. Have a lovely evening. God bless.
Thank you.
Thanks.
Thank you. Before you go, so I will contact the 2 of you, Alasdair. I've got a suggestion, because I think particularly with tonight, many doctors are afraid to do certain things because of what they perceive the regulations and the guidelines to be very limiting. And I think in this case, I really feel strongly that I would like to answer every question that is in there, but in a different platform. I'll contact you, and then we can see how we can agree on that.
Okay, so presumably, Casey, that you guys will capture all the questions, and if you do so, send them in a spreadsheet, then we can answer.
That's what I'm looking for, and you can answer them, and then I will publish them on one of the legal bulletins or whatever it is.
So those who haven't come off the webinar will now realise that we're going to answer the questions. So that's good. that's good news for them. So yeah,
yeah. Because I really think sometimes our members are lost, and they're so afraid of the law. But I think the more information, specific information we give them, it may allow them some room to breathe, so they know that this is allowable, this is not allowable.
Okay.
All
Brilliant.
right. Guys, thank you so much. I'm going to conclude the meeting, and thank you to the two of you. Great stuff. Thank you, team.
Yes.
All right.
Thanks,
Good night.
Casey. Good night.
Good night. Good night. We may stop there.
We're in the meeting now.
Thank you.